Welcome to Law Days and Lattes, the podcast where we blend the world of law and business with a warm cup of information and common sense. I'm your host, Sidney Whelan, attorney, real estate investor, and business owner. Each week, we'll be your go-to source for legal insights, business advice, and so much more. Whether you're a seasoned professional, an ambitious entrepreneur, or simply someone seeking guidance, we'll have you covered. From navigating the legal landscape to empowering you with valuable business strategies, we'll explore the legal side of life and enjoy a virtual latte along the way. So, grab your favorite latte, get comfortable, and let's dive into Law Days and Lattes. Welcome back to Law Days and Lattes, your go-to podcast for legal insights over your favorite cup of coffee. I'm Sidney Whelan, your host and founder of the Whelan Law Firm in Moberly, Missouri. Today's episode is a milestone here at Law Days and Lattes, as this is our 50th episode. We are so thankful to our dedicated listeners and to the new listeners out there, as we hope to help you navigate the legal side of life with confidence as we share some advice, some tips, and some stories over a warm cup of coffee. It's been a while since we've talked about guardian and conservatorship, so today I wanted to touch on this important topic and answer some of your questions so that you will know what to do if your family member needs assistance, and what are your responsibilities if you are appointed by the court as guardian or conservator over your loved one. So, whether it's an older family member, a disabled younger adult, or a minor who has come into some money, let's talk about your responsibilities if you are appointed as a person to take care of them or their finances. Grab your favorite cup of coffee and let's get into it. Guardianships and conservatorships play a crucial role in safeguarding the rights and well-being of vulnerable individuals, including minors and incapacitated adults. Let's start with the first question. What is guardianship? Well, guardianship means obtaining the legal authority to make decisions for another person. A guardian is the person appointed by the court to make decisions on behalf of someone else. The person over whom the guardianship is granted, whether it's a child or an adult, is often referred to as the ward. This type of proceeding means that the guardian is responsible for the well-being and care of the protected person. The guardian will be able to make personal and medical decisions for the person, including healthcare decisions, decisions about where the person will live, and, in the case of children, decisions regarding school. A conservatorship is slightly different. So exactly what is a conservatorship? Well, the conservatorship is the legal authority to make financial decisions for another person. This can be for an adult or a child, although it allows the person named as the conservator to make financial decisions. Court approval is needed to spend any money or to sell any of the person's assets. As for minors, normally parents have the legal right to make decisions for their children. A guardianship may be needed, however, for a child if there is no parent available to take care of that child. And a conservator over the child's assets may be needed if the child inherits assets from a deceased relative, for instance, life insurance or cash accounts. If this is the case, the court may set up a conservatorship for the minors to protect the assets of the child until the child is an adult. A court-ordered conservatorship over a child lasts until the child reaches the age of majority, which is age 18 in most states. To help you perform your duties properly, I'm including a list below, which are the general duties and obligations of a guardian and conservator. First, a guardian or conservator is appointed upon the adjudication of an individual or a respondent as incapacitated or disabled. If you have been appointed the guardian, The respondent is known as a ward. If you've been appointed conservator, the respondent is known as the protectee. If you've been appointed as both guardian and conservator, the respondent is known as both a ward and a protectee. Next, an incapacitated person lacks the ability to make medical or psychiatric treatment decisions, to make placement decisions, to vote, to drive an automobile, and to marry. A disabled person lacks the ability to handle his or own financial resources. If the respondent is adjudicated to be only partially incapacitated or disabled, the extent to which the respondent's rights are limited will be specified by court order. It is the guardian and conservator's duty to prevent the ward or protectee from exercising rights that are limited or rescinded by the court. Next, as the guardian, you have a duty to take charge of the person of the ward and to provide for the ward's care, treatment, living conditions, education, support and maintenance, and the powers and duties shall include assuring that the ward resides in the best and least restrictive setting that's reasonably available. You must assure that the ward receives medical care and other services that are needed, promoting and protecting the care, comfort, safety, health, and welfare of the ward, and providing the required consents on behalf of the ward. To the extent possible, you must encourage the ward to participate in decisions, act on his or her own behalf, and develop or regain the ability to manage his or her own affairs. You will be required to file a personal status report each year concerning the care, welfare, placement, and plans for future care of your ward. Next, as the conservator, you must take possession of your protectee's property to the extent authorized by the court. You must use reasonable efforts to find any income, assets, and liabilities of the protectee. You must identify the needs and preferences of the protectee and work with the guardian and others close to the protectee. You also must prepare a plan for the management of the ward's assets. Provide oversight to any income and assets of the protectee under the control of the protectee. The property and income and bank accounts must be kept separate from your own funds. You must invest the protectee's funds according to the law, and you are personally liable for any unauthorized investments. You may proceed to spend the protectee's funds for purposes authorized by statute or court order. You may apply for an order of continuing support and maintenance, authorizing you to spend a budgeted sum each month for the protectee. You will be required to file an annual accounting, called a settlement, showing in detail all receipts and expenditures occurred during the preceding year. You must also let the court know of the present address of the protectee, your current address, any services being provided to the protectee, and any significant actions taken by you as to the continued need for conservatorship, and any recommended changes, compensation, and a plan for the coming year. Each entry on the settlement must be explained, and each expenditure must be authorized by statute or court order. You may not sell, trade, lease, mortgage, transfer, or discard any of your protectee's property without court approval, even though the protectee is your child or other relative. You may not revoke or amend a durable power of attorney, which the protectee is the principal. Next, your authority as guardian and conservator may be limited by the court appointing you. You must consult your attorney as to legal limitations resulting from your ward or your protectee's adjudication and to the extent of your authority allowed by the court. In the event your ward dies or you or the ward move from one address to another, you have a duty to notify the court in writing of such death or new address as soon as possible. You are also under a duty at all times to act in the best interest of your ward or protectee and to avoid any conflicts of interest which impair your ability to act. You must also be reasonably accessible to your ward. If you fail to perform any of your duties as guardian or conservator, you are liable to be removed from office and may be held personally liable for any loss or damage sustained by your ward by reason of your failure. In certain cases, expenses of bond and other costs may be saved by depositing the ward's funds in a restricted bank account. Under Missouri law, a conservator who is not a licensed attorney cannot represent the protectee's estate in connection with court proceedings, whether you're appearing in court or preparing pleadings to be filed with the court. It's important to understand that you must retain an attorney to perform those legal services required of you. On order of the court, the attorney may be compensated for services reasonably necessary from your protectee's estate. So remember, follow the advice of your attorney, talk to your attorney before taking any action, and remember you are under a duty at all times to act in the best interest of your ward or protectee and to avoid any conflicts of interest which might impair your ability to act. You must also be reasonably accessible to your ward. And if you fail to perform any of your duties as guardian or conservator, you are liable to be removed from office and may be held personally liable for any loss or damage sustained by the ward by reason of your failure. In certain cases, the court may require you to post bond in order to serve as the conservator. The court may waive the requirement and expense of bond by placing the funds in the restricted deposit. Your attorney, of course, will be able to assist you with these issues. As you can see, being appointed as the guardian or conservator for care and responsibility of someone else is a big responsibility, and the courts take this role very seriously. So throughout this episode, we've explored the various types of guardianships, legal processes, and your rights and responsibilities as guardian and conservator. It's evident that effective guardianship practices are essential for ensuring that those in need receive proper care and protection. And it's incumbent on all of us, including lawmakers, legal professionals, medical providers, caregivers, and communities, to prioritize the protections and the services for our most vulnerable citizens. We must continue to advocate for and implement practices that safeguard their care and dignity, prevent abuse, and provide them with the best quality of life. If you found this episode helpful, be sure to subscribe to Lattes on Lattes for more legal insights. And if you have a topic you'd like me to cover, send me a message. Be sure to like and follow this podcast so that you don't miss a single episode. And be sure to share it with your friends and family so that they too can benefit from this information. As always, my friends, grab a cup of coffee or your favorite latte. Hold your loved ones tight and have a great week.
This podcast episode contains general information for discussion purposes only. Each case is different and must be judged on its own merits. Missouri rules generally prohibit lawyers from advertising that they specialize in particular areas of the law. This show should not be construed to suggest such specialization. Nothing on this show should be taken as legal advice for any individual case or situation. This information is not intended to create an attorney-client relationship, and the listening or viewing of this podcast does not constitute an attorney-client relationship. The choice of a lawyer is an important decision and should not be based solely upon advertisements.